In this video, we will conclude our look at the parole evidence rule by examining the exceptions to the rule. And by exceptions, what I really mean is types of extrinsic evidence to which the parole evidence rule is inapplicable, to which the parole evidence rule does not apply. So, more correctly, in this video, we will highlight some important boundaries that limit the scope of the parole evidence rule. The upshot of this video is to not overthink the parole evidence rule. The parole evidence rule does not apply every time a party wishes to introduce extrinsic evidence in a contract dispute. So, what are some exceptions to the parole evidence rule? Let's start where we concluded in the last video. Where extrinsic evidence is being introduced to explain or resolve ambiguity in a written agreement, thus, the extrinsic evidence is not being used to contradict the terms of the writing or to supplement the writing with additional terms, but instead the extrinsic evidence is being offered to help the court understand what the terms of a written agreement mean. As we covered in the last video, courts in different jurisdictions disagree about when the express language of a written agreement is ambiguous. But assuming the court finds the written agreement to be ambiguous, extrinsic evidence may be admitted to help resolve the ambiguity. In this context, the parole evidence rule has no application. The parole evidence rule only applies where one party is claiming that the parties had agreed to terms that were different than or in addition to the terms that are in their written agreement. Second, the parole evidence rule has no application where the extrinsic evidence is being introduced to show that the parties had a subsequent agreement or understanding to modify the written agreement. Remember, the parole evidence rule applies only to prior or contemporaneous agreements or understandings between the parties, agreements or understandings that the parties may have had prior to or contemporaneous with the adoption of their written agreement. The parole evidence rule does not apply to agreements between the parties made after the written agreement was adopted. Thus, to again revisit our discussion of contract modifications, a subsequent course of performance between the parties that deviates from or conflicts with the parties' written agreement can operate as an implied modification of the parties' written agreement. The parties' objective manifestation of mutual assent to the modification is implied through conduct. Extrinsic evidence of that subsequent course of performance is never barred by the parole evidence rule. Indeed, that is the reason for no oral modification clauses. Oftentimes, NOM clauses will be coupled with merger clauses. NOM clauses aim to ensure that things that the parties might say or agree to orally after the written agreement is signed do not modify their written agreement with different or additional terms. Finally, the parole evidence rule does not preclude extrinsic evidence to show the written agreement is unenforceable if one party is asserting a defense to the enforceability of that agreement. All of the common law defenses to the enforceability of the contract, defenses including fraud, duress, mistake, and unconscionability, all tend to revolve around something happening prior to the formation of the contract, something that somehow tainted the parties' assent to the terms of the contract. Again, where the extrinsic evidence is being offered not to contradict the terms of the written agreement or to supplement those terms with additional terms, but instead being offered to show that the written agreement is unenforceable due to some valid defense to enforceability, the parole evidence rule is inapplicable. The parole evidence rule will not bar the admissibility of such evidence. So, that concludes our examination of the parole evidence rule under UCC Article 2. Again, the sole purpose of this short video is to re-emphasize the point that the parole evidence rule plays only a limited and discrete role. The parole evidence rule does not apply anytime a party wishes to offer extrinsic evidence in a contract dispute. As I said at the outset of this module, I hope you now feel confident, maybe even eager to apply the parole evidence rule, both for purposes of this course and also for the bar exam. In next week's module, we will move on from our examination of the terms of a contract for the sale of goods and into a new stage of the course, one that deals with questions of performance, breach, and remedies.